Good morning, everyone. Virgo here. It is September 17th, 2019. Happy Tuesday to everyone. And we're going to be having a little kind of lesson this morning. And the reason that I'm doing this is because I need everybody to collectively understand what it is that's happening with this Sharon Tracy Gale Bay case that we've all been following so closely. And I need for people to be able to see how bail is determined and how it works in Pennsylvania. It's different than in other states. So just to give you an example, in California, for example, if you are arrested and you have a $10,000 bail, you are required to come up with 10% of that in cash, and the remaining amount you must go to a bail bondsman for their assistance, because you are required to come up with an equal amount of collateral in order for them to post bail for you. So that's the way that it works in the majority of states. But in the Commonwealth of Pennsylvania, things are a little bit different. So let's go ahead and read through this very short little section on how bail is determined in Pennsylvania so that you understand that part of it. And then we'll go over and talk about the docket, what's been removed, what's been replaced, and what is happening in this actual case in terms of Sharon Tracy Gale Bay. All right, so first of all, what is bail? Bail is security that they put on a person to ensure that they appear for court and do not violate any conditions imposed. You can get in trouble if you do not show up or violate a condition. The penalties that you receive for violating a condition or for not showing up in court are your bail gets revoked, which means your bail is withdrawn and you go directly to jail. They can also ask for forfeiture of bail. That means they can ask for either all of the bail money back or part of the money. It all depends on what the district attorney and the court system chooses to do. It is very important not only to show up, but also to stay out of trouble. If you pay a bail bondsman and the bail bondsman puts up the bond, you do not appear or violate a condition, the bail can be revoked or forfeited. If the bail is forfeited, the bail bondsman pays the court the amount of money he put up or some portion of that money. Then the bail bondsman will come after you or the person who secured the bail to get the money back, which could include foreclosing a property or taking whatever collateral that has been put up. The bail bondsman has a contractual right to do so. How bail is determined is totally up to the magistrate who sets the bail. The bail can be determined any way the magistrate sees fit, as long as they follow the law. Bail can be unsecured or up to $1 million+. It all depends on the magistrate's mood that day, the type of charges that are filed, and several other factors. There is no set amount per charge. It is totally dependent on what the magistrate wants to do. All right, but there are some other conditions constitutionally for that particular state. There are three types of bail. There's unsecured, released on your own recognizance, and secured. Unsecured bail means you sign your name and the magistrate assigns a monetary value. By signing your name, you get to go home. However, if you violate a condition or you fail to appear, they can put you in jail and then come after you for the amount of the money that was originally set. No money needs to be paid when unsecured bail is set. Release on your own recognizance is just signing your name and walking away with no amount of money set. Security means you have to post money to stay out of jail. If there is a violation of the condition or failure to appear in court, the government can take all or part of the money that's posted. They can also go after you for the remainder amount. The general conditions are you have to show up in court every time. You cannot get charged with another criminal offense. You have to notify the bail agency within 48 hours of any change of address If you're not using a bail bondsman, your bail agency then becomes the court, just so you guys know. You have to refrain from intimidating witnesses. The two things that get people in the most trouble on bail are getting charged again and contacting the actual witnesses. Magistrates can set special conditions such as no illegal drug use, no drinking of alcohol, not appearing at certain establishments that serve alcohol, not going to certain locations where you have been guilty of causing a ruckus or trying to talk to witnesses, these types of things. There's also conditions that can be set with regards to things like putting ankle bracelets on and those sorts of things. Is the bail available to everyone charged with a crime? Yes, except for homicide charges. Okay, so there's three types: the unsecured, release on your own recognizance, or secured bail. Now, everybody gets the opportunity for bail. According to the court, $100,000 bail is actually a very large amount of bail. Here's the reason why. Because the only time that there is a denial of bail is when it is on a murder charge or a charge that could get the death penalty. That is what was expressed to me when I spoke to them on the phone. Now, having said all of that, let's go over and look at the actual case again. All right, so we know that these are not life in prison or possible death penalty charges. These are charges, some of them are serious, but the majority of them are certainly not serious to get more than a few years. All right, so having said that, the judge is looking at this docket and trying to determine what to do based on the fact that Sharon jumped bail the last time around. All right, so what he does is he doubles the $50,000, makes it $100,000. Now, in this particular Commonwealth, the percentage that is required is 10%. That is regular standard, okay? With that being said, now that does not mean that the $100,000 never comes into play. So this is what I want you to focus on. 10% is what's required to bail Sharon out. But whomsoever it is that bails her out is required to sign their signature on a statement that says, if Sharon takes off and does not appear in court again, as she has been guilty of doing already once, the parties that have their signature on file of who is bailing her out will be the ones that the court will send the police after. So they are completely responsible for the full amount of that $100,000, meaning that Sharon takes off. There's a 30-day period she has to turn herself back in. If she does not turn herself back in within that 30-day period, that $100,000 becomes due and payable by the parties that signed to get her out in the first place. So know this: the people who go to post bail for Sharon, if you sign your name, you become responsible for that $100,000 bail if Sharon doesn't show up to every single court date, or if she gets herself in trouble in another way. Bail forfeiture is something that they come after the poster for. All right, so those are the conditions currently. Now, the conditions that the bail modification conditions set that you guys see, there was only one that had been posted so far in the actual docket that was able to be seen by the clerk. And that was that Sharon is required to stay away from the street that she lived on because she's been harassing neighbors and filing fake liens against people on that street. So Harwood Avenue, or whatever the street name was in Upper Darby, that they actually removed her from the property. That home, that street, she is required to stay a certain amount away from that area. Now, other conditions were not available to be told over the phone to anybody or seen. So we are not going to know if or what these other conditions are until, either she's bailed out or until, well, it wouldn't even become a factor. If she's got a court date coming up here on the 15th of October. So here's what's going to happen. They can bail her out. They can bail her out all day long. If they want to put their butts on the line for $100,000, then they're welcome to do that. I would imagine that they're brainwashed enough to actually believe that $100,000 they can pay off with some kind of crazy squirrely trust account that doesn't exist. But that's not true. It's really $100,000, and it is something that can put you behind bars, no matter how innocent you might be in trying to help Sharon, if Sharon takes off again and doesn't turn herself in within 30 days. That $100,000 now becomes payable by the person who posted bond or posted bail for her with the 10%. But regardless, she would only be out for a very short period of time, because what's going to happen is the hearing is going to take place on the 15th of October. And once she is sentenced to whatever, and she will be sentenced to something. You don't have 7 felony charges and not get sentenced and walk scot-free, no matter what everybody in this area of the consulate Moors believe. That simply doesn't happen. There is not one single case on the books that suggests that any of the garbage that's being filed with regards to this case works. Another issue is this is a case that's being done pro se by Sharon. It is not a smart move. She really needs representation. If she continues to go in that direction, her chances are even worse of coming out of this in a good way. But regardless, if she gets bailed out, she's bailed out for a very, very short period of time before the actual hearing starts. Once sentencing is done, she's taken into custody if she gets jail time. So that's where we stand right now, ladies and gentlemen. If anybody's got any questions, please feel free to put them in the comment section. You're able to pull up, using the link that's in the description of this video, the docket sheet, so that you can take a look at it yourself. So yes, it is 10% of the actual $100,000 that must be posted for her to be released on bail with special conditions. However, the person that actually signs that piece of paper is on the hook for the full $100,000 should Sharon take off again. All right, everybody. I hope this explains some to you and helps to explain why the bail was posted put up there a second time. It is required. This is not a case that is a death penalty case. This is not a life imprisonment case, and because of that, bail has to be offered. So it is up to the magistrate. This particular judge decided to double it in order to ensure that there was some security. So that's where we're at, and I will continue to follow it, as you guys know. But the next hearing is on the 15th of October. All right, everybody. I hope you have a great day, and I will talk to you all soon. Bye-bye.